Dear viewers, for the last time, welcome back. In this final video, we present a few critical views on the AI Act, highlighting both its positive and negative features. Concretely, each member of our team details one of the strengths and one of the weaknesses of the text for all the topics we delved into in our former videos. Let's get started. Firstly, as to the scope of the regulation, it is very broad. This is due to the wide definitions adopted, to the number of actors targeted, and also to the applicability of the text outside of the EU. This is clearly positive, as many situations involving AI will be captured, which is convenient for a regulation called AI Act. It also means that there will be no competitive edge for non-EU actors over EU undertakings when the former systems or their outputs are used in the EU. Yet, in a more critical perspective, we note that some notions are left undefined by the regulation. For instance, affected persons are not explicitly defined, although this category of persons receives a right to explanation of individual decision-making. Hence, properly identifying the beneficiaries of explanation rights could prove problematic.
The risk-based approach is a welcome and balanced approach that makes it possible to subject operators of AI systems to obligations that are proportionate to the risks their system pose, and to lighten the regulatory burden on operators of systems with limited or minimal risks. Nevertheless, in terms of its implementation, some difficulties may arise in the future, especially for prohibited practices. Article 5 of the AI Act is based on a limited, exhaustive list of forbidden practices, such as some forms of social scoring. This static approach raises questions about potentially problematic practices that do not exist yet. Contrary to what is planned for the high-risk AI systems listed in Annex 3, the AI Act does not delegate the power to amend the list of prohibited practices to the Commission. Although the Commission is tasked with annually assessing the adequacy of the list of prohibited practices, it does not resolve the issue at stake either. Indeed, modifying this list based on the Commission findings would still require the agreement of both the EU Council and the European Parliament through a formal process of revision of the AI Act. This raises the question of why Article 5's list was set in stone. An approach setting out objective criteria directly in Article 5 for assessing whether a practice presents or will present in the future unacceptable risks could have mitigated this difficulty. Although they were not initially included in the Commission's proposal, binding rules on general-purpose AI models were added to the AI Act during the political negotiations leading to its adoption. This addition is highly beneficial, as a total absence of rules on such popular and powerful models would have been a missed opportunity, especially for an act meant to regulate AI in an horizontal manner. Nevertheless, regarding the criterion used to classify GPI models as presenting systemic risks, critiques can be made. The AI Act automatically presumes that a GPI model has high impact capabilities when the cumulative amount of computation used for its training, measured in floating point operations, exceeds 10 exponent 25. Hence, this presumption, although it is rebutable, solely relies on computational power, thereby failing to take into account the number of downstream applications that incorporate a GP model, and or the number of actual end users of a GP model, which could be more reliable criteria to assess the impact of a given GPI model towards society. Paradoxically, such criteria are mandatorily taken into consideration by the Commission when it adopts a decision qualifying a GPI model as having high impact capabilities and hence presenting a systemic risk.
The requirement imposed on high-risk systems provide a fairly detailed framework to limit the potential risks to health, safety, and fundamental rights caused by such systems, which is clearly positive. In particular, the regulation emphasizes and deeply details the role of humans who must monitor and maintain control over AI systems. That helps maintain high ethical standards and accountability. However, in practice, complying with all these obligations won't be easy. Each material provision is long and complex, making it tough for those subject to the regulation, especially providers of high-risk AI systems, to ensure every requirement is implemented correctly, despite the forthcoming adoption of harmonized standards and/or common specifications.
Admittedly, the transparency requirements imposed on so-called limited risk systems do not impose the disclosure of much information, though these requirements bring in more than that. They also have the potential to support the prohibition of certain AI systems or practices. For instance, considering the systems used for deceptive or manipulative purposes, it will likely be more difficult to manipulate persons when they know they are interacting with an AI rather than with a human. Similarly, revealing the AI-generated nature of contents helps to tackle the problem of mass manipulation and disinformation. Regardless of that positive feature of the AI Act, it should also be emphasized that the porous boundary between limited risk and high-risk system is not sufficiently highlighted in the AI Act. Providers and deployers could be misled into thinking that they only belong to the limited risk category, e.g. for emotion recognition system, whereas both risk categories are actually met.
Any actor may end up qualifying as a provider of a high-risk AI system in some situations. For example, it will be the case if any actor makes a substantial modification to a high-risk AI system insofar as it remains high-risk after its modification. This rule is highly beneficial as it holds all actors accountable for their actions towards AI systems, while also preventing the imposition of excessive obligations on the initial providers. In contrast, a criticism of the provisions on the AI value chain is that third-party suppliers are not directly targeted by the material obligations of the regulation. They are solely required to enter into a written agreement with the provider, which includes the provision of the information necessary for that provider to achieve compliance. It would have been more effective to impose material obligations directly on such third-party suppliers, similarly to how the GDPR deals with data processors, to ensure compliance by design of AI systems.
Regulatory sandboxes have rarely been used at EU level as of now. Yet, they are a wonderful mechanism. In the framework of the AI Act, sandboxes could help European companies bring the devices to market faster and hence make them more competitive. Besides, for those benefiting from such sandboxes, the regulatory burden will be partly supported by public authorities, while benefiting from personalized guidance. However, this mechanism will only work if the consequences attached to the operator's participation in a sandbox are made clear from the outset. As of now, the AI Act solely provides that the participation to a sandbox must be taken positively into account by public authorities to a reasonable extent. The lack of legal certainty as to the outcomes of sandboxes might weaken the usefulness of and willingness to engage in this type of mechanism for market operators.
Conformity assessment procedures under the AI Act are imposed in order to ensure that high-risk AI systems comply with the applicable requirements. A positive assessment results in the CE marking being affixed to the AI system. The same logic also prevails in other product safety legislations. This approach positively contributes to fulfilling one of the purposes of the regulation: building trust in AI systems, especially when third-party assessments are conducted. However, this trust can be jeopardized by the derogations to conformity assessment procedures set out in the AI Act. Specifically, in certain situations, law enforcement and civil protection authorities are not required to obtain prior authorization from the Market Surveillance Authority to place a high-risk AI system on the market or to put it into service, but they still have to obtain such an authorization ex post. Furthermore, these derogations to the principle of prior authorization are not strictly defined, both in terms of scope, for instance, what is exactly an urgent situation involving exceptional public security reasons, and regarding the time frame for obtaining an ex post authorization. Indeed, the regulation merely states that such an authorization must be requested during or after the use without undue delay. This lack of precision could lead to dangerous misuses of these derogations.
Regarding its enforcement, one might note that the AI Act creates an impressive architecture designed to ensure its coherent and effective application. The clear distribution of tasks amongst EU and national authorities, their respective powers, and the range of sanctions that they may impose appear as positive features of the text. Nonetheless, the vast number of authorities to be created or appointed at member states level, potentially over a few hundred, might lead to a fragmented application of the regulation, despite the AI board's coordination mechanism. Besides, it will likely be complex for all such authorities to achieve sufficient expertise in AI so as to fulfill their duties properly.
The evolutive nature of the annexes to the regulation participate to the flexibility of the AI Act and make it likely to adapt to technological development of AI systems on the long run. This is a result, in particular, of the fact that the EU Commission is empowered to adopt delegated acts to modify some of these annexes content, for instance regarding Annex 3 and 7. While this evolutive nature should be welcomed, such flexibility comes with challenges. First, allowing the Commission to amend the third annex, that is to say the list of cases in which an AI system is high risk, is virtually equivalent to an authorization to modify the scope of the text, which, all in all, mostly focuses on such systems. Second, allowing the Commission to modify Annex 7 on the third-party conformity assessment procedure at any time bears the risk of changing the rules to be applied by numerous notified bodies, which might cause additional burdens and potential delays in the assessment of AI systems.
Finally, as a concluding remark, we want to broaden the discussion and highlight that AI is not only regulated through the AI Act. Beyond this new regulation, there is a vast body of rules that already apply to AI, although these rules are not specifically designed to deal with AI. Indeed, laws that are in force apply to situations that fall within their scope of application, regardless of the technology used. They may therefore be used to regulate AI. For instance, such is the case for consumer protection, personal data protection, intellectual property, etc. Want to know more about the global picture? Find out how AI is regulated in a broader perspective, or even dig deeper into the AI Act? Don't hesitate to reach out.